Okay, so this session, which I am very honored to moderate this morning, is looking at strategies for reducing excessive pretrial detention. We heard yesterday, and all of us are very aware that issues of pretrial detention are some of the most serious that we're facing as governments, as countries, as legal aid providers. And what this session is going to do in a very practical way is to look at different country experiences in practically trying to address this problem so that we can think a little bit about what we might be able to do in our own countries to think about this issue in another way. So my first speaker, who we were able to hear from yesterday, is Anika Holterhof. She is the Crime Prevention and Criminal Justice Officer, the focal point for legal aid. She's the legal aid expert at the United Nations Office on Drugs and Crime. She has been working with a number of countries on how they are reducing the scope of imprisonment and excessive use of pretrial detention. I'm just going to share with us some effective strategies that UNODC has been able to see and to work with over the years. Anika?
Sorry, I promise I'm not in every panel of this conference. It's just that there are just two of us, so you have to bear with me one more time. I had a presentation, but I don't need it. If it's not there, it's okay. I think we're all still awake, so. I would like to just introduce the topic, basically. UNODC, as you know, works on a lot of issues with countries, with judges, prosecutors, and also with people like you who provide legal services to reduce the scope of imprisonment, but also on issues of organized crime, drug crimes, everything that you know very well from the reality on the ground is very interconnected. And for many years, we have had a Global Prison Challenges program, that's the name, where we basically cut the problem in three parts. And the first part is what I would like to talk to you about today, reducing the scope of imprisonment. The second part is about improving prisoners' lives, where of course legal aid has its role as well, but I would like to focus on the first two. And I think the idea of connecting legal aid and the application of non-custodial measures is something that we very often mention, but in practice it's very difficult to do it and also to advocate for it. And it helps that we have now this indicator that we are all not entirely happy with, but it's there under Goal 16 of the Sustainable Development Goals, which asks countries to report on the number of unsentenced detainees as a proportion of the overall prison population. And we know also from what speakers shared yesterday, the numbers that were mentioned, that in many countries, even if prison rates are not very high overall, compared to the entire population of the country, usually the remand population of prisoners is very high. We have, as you can imagine, an international framework on that. But I would really like to stress that the rules, and I'm just going to say the names again so you remember them, but please look at them, because what is the idea behind these non-binding standards and norms that we work with, that UNDP works with, that all the UN system works with, is that these are collections of things that work in countries and they give very practical advice. And for reducing pretrial detention, there are actually 4 that can be very useful for states when they think of legal reform and when they think of the obligations they have towards these vulnerable people. And these are, first of all, the Tokyo rules, which deal with non-custodial measures, the Bangkok rules that deal with women prisoners' treatment, and non-custodial measures explicitly for women. And then, of course, the UN principles and guidelines that we have been discussing for the last day. And then the newest edition, the Nelson Mandela rules, which are in themselves not new. They are the revised United Nations Standard Minimum Rules for the treatment of prisoners, but they were revised and adopted in 2015 with the name Nelson Mandela rules. The challenge of pretrial detention, you know, and prison overcrowding that is connected with it is very complex. There are several actors in the justice system that are connected to these decisions that are made. The information that is passed is someone who is picked up by the police and put in pretrial detention, put in touch with the right people. Are the judges informed? Are the prosecutors informed? It is also something which has a high need but a shortage of availability of proper advice to the people that are concerned. Corruption is a big issue at this entry point in the justice system in many countries across all the development levels. And it should, of course, be applied as a last resort, but in many countries, even if judges, prosecutors, and lawyers are saying we should the presumption of innocence is the highest good. It's sometimes just easier when you have a lot of cases to deal with and a lot of people that have been recently picked up by the police or put in pretrial detention. It's easier to put them in pretrial detention and leave them there for a while instead of doing lengthy investigations into their personal case and actually releasing them. So how do you reduce pretrial detention rates? And the other speakers will talk about examples from countries. But just as an overall overview, of course, non-custodial measures, they should be used whenever it is appropriate and as early as possible to prevent arbitrary arrests and reduce the pre-charge detention period. And then, of course, also applying them to reduce the pretrial detention post-charge, which are two different things, but very often they are confused also by lawyers, like, has the person been charged? Has he or she not been charged? Is maybe there a revision of the case? And then, as we have heard also from the very charismatic speaker this morning, things like diversion from the criminal justice system. Is this someone who needs treatment? Is this someone who maybe while the justice system is looking and investigating the case, in this period, should this person not be put in treatment? In a treatment, and as we've heard before, also treatment sometimes is applied without looking at what the person really needs. Will a 20-day drug program really do something good? Is this a juvenile person that maybe needs different help? And then, of course, reducing the duration of the overall pretrial detention. What we encounter when we work, especially with people who are able to ask for non-custodial measures, and these are not only the prosecutors, as you know, these are also the lawyers. It could be that prosecutors do not think of applying these measures, or that a judge is reluctant to apply them, even though the judge knows that this is a rule in the national system. And this is the problem with confidence. In a lot of countries, especially nowadays, the move is toward tough on crime. You put away the people, you can present the rates, the government can say, look how many people we arrested, look how many people were convicted, and it doesn't really go well with the public in some districts, in some cities, or even in the country. If you say so many people were released, so many people were put in treatment, and people think even if someone has been charged with a non-violent crime where the sentence he or she would get is not even imprisonment, as long as it's not clear if that person is a criminal or not, we don't presume they're innocent, and we see what we can do for them in the period until this is established. We just lock them away so we can be sure. And this is a big problem, and we started to work more with countries on awareness raising and really seeing if there are cases, particularly from the community or from the country at least, where we can show this is someone where a non-custodial measure was applied because the lawyer asked for it or because the prosecutor asked for it, and we can show how this person within the community developed well, so to say, as an advertisement for public support in the system. And of course, the knowledge of all the lawyers involved, the defense lawyer, the judge, the prosecutor, of the non-custodial measures that are applicable in the national system and to which offenses they are applicable. It is extremely important. And there have to be national laws that give them an appropriate choice. There also has to be adequate guidance for judges and prosecutors on how to apply them, so that the judge in Tbilisi does not decide a case differently than maybe at a district court that is 100 kilometers away. This is something that the state has to look into. And if you look particularly at legal aid, you can look at guideline 4 of the principles and guidelines, and I'm not going to go into much detail now because it is pretty much a list of what legal aid at the pretrial stage should do. And I would like to finally mention the 2 new provisions in the Nelson Mandela rules that we have seen in the few years after their adoption have had quite an impact in legal reform with states. Because when they were revised, new services, so to say, that are important to prisoners were added that in the 70s were not added. And these are about prisoners' rights to access effective legal representation and where needed legal aid. And there are 4 new rules, and 2 of them, Rules 119 and 120, that reference the basic rules, they apply specifically to the untried prisoners because countries saw that there was a need to highlight their case. So for us, it's very important as I said before, to raise awareness of non-custodial measures and also of the right to access legal representation, legal aid for prisoners. We have a handbook on strategies to reduce overcrowding in prisons. I will invite you to download it, but I'm not going into detail about that because it's quite extensive. But not only is it important to have early access to protect the vulnerable people, it's also important to raise awareness amongst all the people that deal with them, the prison staff specifically. So what we have been doing is some way going back to basic, because we saw what works in countries. So we started, and I'm sorry, I just have this one, but this gives you an idea about all the new rules of the Mandela rules that were not yet known to many countries, that this is a basic right of the prisoner, like access to health care, and this is the one on access to legal aid. We have it in all the UN languages, we're translating it into a lot more, and we have seen in some pilot projects where we just put them in prisons, in the local language, that both prison officers that are taught, and we heard yesterday from Natalie Rea how important it is when laws change, when countries adopt more measures, that also the prison staff up to the tiniest village is aware of what they have to do to support the rights of the prisoners, but also for the prisoners. So this is, it doesn't have to be this flashy, like people can also just print it, but we've seen that going back to these very basic things, going away from the smartphones and all this, if you see it every day, you don't forget that you have this right. And finally, then we have something that is the opposite of that, that's very electronic. We are currently finalizing, hopefully to be ready in January or February, an online training course on the Nelson Mandela rules for prison staff, that people can have an account in our online learning system, and they can actually train, or they can train with a trainer, where we have scenarios. And we filmed them in real prisons, in Algeria, in Switzerland, in Argentina, to have different settings, to have different languages, with real prison staff and real prisoners, of course, who all agreed on having their faces on this scenario. But one of the scenarios is the legal rights of the prisoners, who really, where we have a very realistic scenario of what happens, a request from a prisoner to a prison guard, and then we act out the different ways of behavior that happen in reality. And in the end, people are supposed to say, okay, this is what he should have done, this is where he went wrong, this is the rules that he broke, and also to think about, okay, what would I do? So this is just another support to raise awareness of what people should be doing. And finally, as a recommendation, of course, we constantly keep reminding people of the importance of partnerships, not just between the lawyers in the criminal justice system, the judges, the prosecutors, and the lawyers, but also with NGOs, with paralegal organizations that can really come and make a difference. If we encounter many times that prison guards say, we don't know anyone we can call to provide legal aid. Maybe it's enough if he gets some legal advice, maybe he can talk to a paralegal. And yes, of course, if there is only a paralegal, of course, that one is the first defense, and that paralegal can decide if a proper lawyer that can take legal action is needed to come. Finally, we've seen that experience exchange is very important. I'm sure in many countries that you represent, you have started to implement schemes to reduce pretrial detention, to help spread the knowledge of non-custodial measures, and I would like to very much encourage you to continue to do that, and I hope we have a nice discussion now. Thank you very much.
Thank you, Anika, for setting the stage and reminding us that although we all know that there's a right to liberty and a presumption of innocence in our countries, the reality is that it's easier to hold someone in detention than to release them. So we're going to hear now from some country experts about some innovations that are happening in their countries for us to consider. And we're going to start with Finland. Nina Solas-Iloniemi is the leading public legal aid attorney of the Helsinki Legal Aid Office. In this capacity, she leads the office, including exercising state management of legal aid and taking part in legislative reform and international cooperation. I met Nina a few weeks ago, and I thought it was amazing because we were talking about the number of kids in detention, and I think she said there were like 8 kids that were detained pre-trial last year. And I think Finland is a great example of actually trying to put into practice this ideal that we should not be detaining people pre-trial if it is not necessary and not required under the law. Thank you.
Okay, yeah. Okay, good morning, everybody. First of all, let me say that I really enjoyed the first day here at the conference, and I want to thank the organizers for such a fine event. And first I'll start my presentation with the statistics, which should be coming soon, yeah. But I'll start by saying that the pretrial detention rates in Finland have stayed much or less the same, in the same level throughout the 21st century, and even also before that. So in year 2016, there were altogether 1,949 people in pretrial detention, of which 37 were children from 15 to 17 years of age, and 163 were young people from 18 to 20 years of age, and the rest were then adults over 21 years. And the next slide is of rates. Thank you. Okay, thank you. And the rates from 2017 show you that the rates, they do not much change from year to year. Here, yeah. The amount of people who got convicted in courts in year 2016 was approximately 50,000, of which 1,521 were children of age 15 to 17, 4,597 were young adults from 18 to 20 years of age, and the rest were adults over 21 years. And the total amount of people being charged with crimes in courts in 2016 was approximately 56,000 people. And the approximate time the case was being handled in court was 4 months. And Finland's population in turn, in the end of 2016, was approximately 5.5 million. And this is not working. But one thing to explain these rates, I think, can be that criminal liability starts at the age of 15 in Finland. And also that we have a concept of young offenders, which means that they are being treated more lenient than the adults. And another thing to explain the somewhat low numbers is probably 3 principles adapted to Finland's Coercive Measures Act: proportionality, minimum intervention, and sensitivity. And the principle of proportionality states when the use of coercive measures is okay. That is, when they are deemed justifiable with consideration to the seriousness of the crime and when the importance of investigation demands it, while also taking into account how much it infringes on the rights of the suspect or others. Okay. So there was the principle of proportionality, and then the principle of minimum intervention states how to use the coercive measures. They should not be used any more than is necessary to achieve the purpose, and they should not cause anyone undue loss or impediment. And principle of sensitivity states that the use of coercive measures should always be discreet. And we in Finland, we are the big believers of these international conventions and acts. So the principles of our Coercive Measures Act derive from these conventions. According to the Finnish law, a person suspected on probable grounds, okay, this should be going forward again, yeah. Here is the Coercive Measures Act's state of law rule that says that according to that the person suspected on probable grounds in an offense may be arrested or remanded if the maximum punishment is at least 2 years of imprisonment. If the maximum punishment is less than 2 years but more than 1 year, there has to be also other prerequisites for arrest or remand, like if the person tries to avoid the investigation, trial, or enforcement of punishment, or tries to hinder the investigation or continues his or her criminal activity. And also, if the identity of the suspect is unknown and he or she refuses to give the information, or the suspect does not have a permanent residence in Finland and it is probable that he or she shall leave the country before the case is resolved. One thing to explain the detention rates in Finland is probably also that the Coercive Measures Act allows the remanded person to request a new remand hearing every 2 weeks. So every 2 weeks we can ask for the court to take the case to another hearing and try to explain on our client's behalf that why he or she should be released from the pretrial detention. And what comes to the early access to legal aid, even the High Court of Finland has nowadays stated that if a person does not give up his right to have a lawyer in a police interrogation, that interrogation can't be used against him as an evidence in the court of law. And I think this is also a very important rule in the Coercive Measures Act. As I said earlier, children under 15 years of age can't be arrested or remanded because they are not criminally liable. There are other means that to deal with children. And this is my last slide and last effort to try to explain the numbers in Finland, and I think this is also an important rule of law. Criminal Code of Finland states that when we try to think the choice between the conditional and unconditional imprisonment, that we must always take into the consideration that there has to be weighty reasons if a minor is condemned to unconditional imprisonment. So this means all the children under 18 years of age, and such a reason that a child under 18 years of age should be condemned to unconditional imprisonment could be the seriousness of the crime. But I think that this is an important rule in Finland, and this also hinders the use of coercive measures, because also they can't be put into the prison after the pretrial detention, so they can't also use very easily the coercive measures to children. And of course we try, as legal aid attorneys, we try to also think and say to the court we have also other kinds of means to help the pretrial investigation. Like we can ask that instead of putting the client to pretrial detention, we can ask that he or she should be given a travel ban or some more lenient way to deal with the dangers of hindering the investigation. But I would like to thank you for your interest.
Thank you, Nina, for outlining, I think, why it's important to make clear to police and prosecutors and courts in what cases they should not be detaining people and not leaving it all to their discretion. I think that's had a huge impact in Finland, as we've seen. Our next speaker is from Brazil. Ms. Roberta Alvim is a federal public defender in the Office of the Union Public Defender of Brazil, and she's going to talk about what I think is very common in many countries. When I met some of her colleagues from Brazil at an early access meeting many years ago, there was discussion about how they have clients or detainees have a right to go to court for the court to determine whether they should be remanded. But in practice, there was not a defense lawyer there to actually defend the individual and to explain to the court why it was this person should not be remanded. And that was resulting in very high pretrial detention rates and these decisions being made on paper rather than having it be a fair process. That has changed, and I think she's going to describe that and the impact that has had in Brazil. Thank you.
Thank you, Jennifer. At first, I'd like to thank you for the invitation to be here. We're from the Federal Public Defender in Brazil. We are very happy to be a part of this event. Thank you very much. Well, I'm here to talk about the legal aid provider's role in reducing the pretrial detention. Let's go. The legal aid providers and the public defender's offices are important to provide access to legal aid in criminal process. It represents a fair trial, showing that the defense is essential for the rule of law. Having a public defender acting in a criminal process on which the accused is not able to afford a lawyer ensures a permanent supervision of the actions taken by criminal prosecution authorities, controlling punitive power, and resisting and reacting to any offense or threat to fundamental rights. According to the Brazilian law, the arrest of any person must be immediately informed to the judge, to the public prosecution, to the family, and to the person indicated by the person arrested. Within 24 hours, the record of the arrest must be brought to a judge. If the accused does not appoint a lawyer, a full copy is to be made available to the public defender's office. As noticed, the law is based on a non-custodial system. The decision of the judicial power are based on papers, giving no right to the arrested person to defend himself in person. In 2015, the National Council of Justice regulated the custody hearing as a measure to fight the culture of punishment in Brazil. This regulation occurred after being provoked by the civil society, several human rights institutions, and the public defender's offices. The custody hearing consists on promptly bringing the incarcerated person before a judge. In Brazil, there are 3 roles for the custody hearing. The main and more important role is to adjust the Brazilian law, penal procedure to international rights treaty, especially to the American Convention of Human Rights. The second custody role is related to the prevention of the policy torture, which ensures the effectiveness of the right of integrity of person deprived of freedom. And the third one is to avoid illegal, arbitrary, and unnecessary arrest. There's a retrospective activity to evaluate whether the arrest is legal or not, and there's also prospective activity to evaluate the necessity and adequacy in maintaining or substituting the arrest. It's an excellent opportunity for the defense to show documents and to discuss about the freedom. According to the National Council of Justice in Brazil, there was violence and claim during the action of arrests in 5% of the custody hearings. There were 10% identified cases that had social assistance, a situation in which the state should have concrete anticipant means to find out, to know, and to offer social assistance for those who do not deserve jail time and are caught by criminal justice system based on vulnerability situation they are in. We also have here the data about the freedom and imprisonment arrest. Around 44% were granted freedom and 55% were converted into preventive arrest. Well, having a statistical criteria, the percentage of provisional prisoners before the implementation of custody hearing around 40%, and the numbers published by the National Council of Justice 55%, we can conclude that custody hearing has not contributed to decrease the pretrial detention in Brazil. As you can see, despite representing a way to fight incarceration, Brazil has a long way on fighting the punitive culture, which is the main reason for the super incarceration in Brazil. It's also important to mention the importance of action of legal aid providers on defending vulnerable groups in prison situation. This year, the Federal Public Defender's Office in Brazil acted on a writ of collective habeas corpus judged by the Supreme Court. It determined the conversion from preventive to house arrest for women who are either pregnant or breastfeeding and mothers with children up to 12 years of age or handicapped, regardless of alternative measures. The Federal Public Defenders defending the protection of youth, the reduction of female incarceration, many of the children and of the society, especially pretrial situations, either by revoking the jail term or converting it to house arrest. So, the legal aid providers have an important role in reducing pretrial detention. Their action, either on defending the vulnerable groups or a custody hearing, try to humanize the criminal process. However, it's important to not count on legislative changes, but on fighting the punitive culture. Thank you very much.
Thank you, Roberta, for talking to us both about the changes in Brazil and also, I think, how important it is to change the culture and have lawyers really be involved in humanizing clients at that initial stage. Our next speaker is from the United States. Mr. Alexander Shalom is a senior supervising attorney with the American Civil Liberties Union in New Jersey, and he's going to talk to us about some new practices being introduced in some jurisdictions in the United States to eliminate cash bail. In many U.S. jurisdictions, as in many of your countries around the world, bail may be set on people who come before the court, and what we've realized is that if you're poor, you can't actually afford bail, so in effect, you are being detained pre-trial. So he's going to talk to us about measures to introduce that and what's happening well, what's not happening well, and what we can learn from that.
Thanks. Good morning. So you might ask, why is someone from the United States, a country with nearly 500,000 people in pretrial detention, telling you anything? And that would be a fair question to ask. The United States has a real problem with incarceration, that is both post-trial and pre-trial. In our pre-trial system, we really have 50 different systems. Each state has its own system of pretrial detention or release. And New Jersey, the state that I'm from, had a particularly silly system for years. And so I'm going to start by telling you a little bit about the old system and then hopefully get into the new system, why I think it's an improvement and why it might provide some useful lessons. So beforehand, so we're talking about in the 5 years ago, let's say, in New Jersey, there was this theoretical presumption of innocence. And in New Jersey, in fact, every single person was entitled to bail. There was no ability to preventatively detain people under any circumstances other than capital cases, and we didn't have the death penalty. So literally everyone got a bail. But that didn't mean they got a bail that they could afford. And so while you weren't technically detained, the result was you were detained. Because if someone says, sure, you can go home as long as you pay $1 million, and you don't have $1 million, you might as well be detained. There's another kind of particularly pernicious feature of the money bail system in the United States, which is we use commercial bail bond agents. So if that bail is set at, let's not say $1 million, but say it's set at $10,000, you have two ways of getting out. One is you can give $10,000 to the court, and if you appear at all your court appearances, when the case is over, you get your money back. But most people don't have $10,000, so we've set up this ridiculous system in the United States where you can pay $1,000 to a private, essentially insurance company, and they will post a bond with the court, and you can go home. However, at the end of the case, whether you're convicted, acquitted, whether you show up or don't show up, you do not get your $1,000 back. So it's this very regressive system that really preyed on poor people to the extent they were even able to access it. And so what we identified was what we call dual system failure. So failures at the top of the system and at the bottom. So at the bottom, the system is the one that we already alluded to, which is poor people, even if they were not dangerous, and even if they were likely to show up, were stuck in jail simply because they didn't have enough money to make bail. And that would leave them in jail for months, sometimes years, waiting for trial. And what we identify, obviously there are these immediate harms that everyone understands from being in prison, but there are also these really concrete impacts on the case results. So people who are in jail pre-trial are more likely to plead guilty. They're more likely to be convicted at trial. If they get convicted, they're more likely to get harsh sentences. And that's true controlling for all sorts of other variables. But then there are also these harmful impacts on one's life. So people lose their jobs when they're detained. They lose family relationships. They lose housing, access to health care. So really harmful to detain people pre-trial, particularly when we know that they're not dangerous. But there's also this other side of the failure, which is the failure at the top. And so you have this small group of very dangerous defendants, or people who are particularly unlikely to show up in court, who also have access to resources. And because we are setting money bail for everyone, those people were free to go and not show up or harm people, kill witnesses, things like that. And so we set about in 2014 to reform our system, and we did so guided really by two principles. The first is from a US Supreme Court case that reminds us that in our system, liberty is the norm, and detention prior to trial must be the carefully limited exception. And so this is really the fight, which is how limited is that exception? If we're going to set up a system that allows in some situations for people to be detained, how often are we going to let that happen? And then the other issue is that we should never have someone detained simply because of her poverty. Okay, so New Jersey has this new model. This is this fancy flow chart of how things work, which I understand that you can't see, so I'm going to try and walk you through it. So now in New Jersey, the first decision point is actually police officers. Police can charge defendants in one of two ways, either with a summons or a warrant. A summons is essentially a court date. They hand the defendant at the police station a time to show up in court and release them. The other possibility is a warrant, which is the defendant goes to the county jail, and I'm going to explain what happens to people charged on warrants. But it's important to note that 70% of defendants are being released on summonses. So people charged with the least serious crimes and even some more serious crimes are being released on summonses, and that's actually a change that I'll explain why it happened soon. So if you're charged on a warrant, you're going to go to the county jail, and within 48 hours, but typically within 24 hours, you will see a judge. You will see a judge, and you will have counsel present, and you will receive what's called a public safety assessment. This is an algorithm that is going to calculate your risk of not showing up in court and your risk of being rearrested. It will do so based on considering 9 factors, including previous arrests, previous convictions, not previous arrests, previous failures to appear, the current charge, and things like that. And so here are the various factors: your age, pending charges. Based on this score, the judge typically will set conditions of release. And so there are lots of different conditions of release that can be given. One of the coolest ones we have, which is available to everyone, is cell phone reminders. Because what we've found is that people who don't show up in court in New Jersey typically aren't going to non-extradition treaty countries like Brazil, though I've always said if I were charged, I'd be in Brazil because it's a much better place to be. But typically they're not fleeing, they're poor, so they don't have access to transportation, or they don't want to miss a day's work because it's going to mean that they won't be able to make rent at the end of the month. And sometimes it's that they have busy lives and they forget. And so now they get a phone call the night before, a text message saying, hey, remember you have court tomorrow. We can also require people to check in by phone. You have to call in once a month to make sure that you're showing up in court, make sure you're staying out of trouble, things of that nature. You can have no contact orders, so you don't meet with victims or witnesses. In some instances, you can even be released on electronic monitoring, where law enforcement can know where you are to make sure you're not going to places you're not supposed to go. But money is basically gone from the system. Almost no one in New Jersey is being released with money as a condition for their release. In fact, there were about 140,000 people arrested in 2017. That was our first year of this system. Incidentally, 44,000 of them were charged on warrants. Money bail was set 44 times. So, one in about 3,000. Don't check my math, but something like that. Extremely rare. Okay. There are then going to be some cases, however, where the prosecutor will say, there are no conditions that will protect the public, that will prevent this person from harming witnesses, and will make sure this person shows up in court. So in those instances, the prosecutor can move for detention. And within 3 to 5 days, there's going to be a hearing before a judge. At that hearing, the defendant is entitled to robust due process protections. Frankly, better due process protections than they were ever entitled to before. So that includes counsel. It includes really significant discovery. So police reports, witness statements, those are all now being provided to the defendant within a week of arrest. The defendant has the right to call witnesses, to offer evidence by proffer. And there's a presumption of release for almost everyone. So the law says unless you are charged with murder or a crime that carries life in prison, the presumption is release, and you can only be detained if the judge finds by clear and convincing evidence that no condition or series of conditions will achieve the purposes of the statute. So that's where we get to kind of that least restrictive model that they were talking about in Finland. So that's that. Okay, liberty's got to be the norm. And so I've explained that we had 140,000 people arrested. 44,000 were charged on warrants, which is a decrease from the past. And the reason for that is police officers now have this risk assessment tool, and they know that if a person is charged with kind of a medium seriousness crime and they score low on the risk assessment tool, the judge is going to release them. So rather than going through the process of charging them on the warrant, police officers are making the decision to charge more people by way of summons. So the number of people detained was 8,043 in 2017. We have a population of about 9 million in New Jersey, so our rate is certainly higher than Finland's. It's about 5.6% of people arrested wound up detained. I think that's, frankly, significantly too high, but this is really the key, which is between 2016 and 2018, our pretrial jail population is down 40%. So it is too high, but our old system was way too high, so I suppose that's incremental improvement. And the thing is, talking about 40% sometimes obscures the impact, and this is, I think, something that public defenders particularly will understand, which is, right, so this is just looking at 1 year's change, so that's about a 25% decrease, but that's 1,885 people who are now free to live their lives while they're facing the criminal charges. They're free to hold down jobs, to be with their families, to keep their housing arrangements. And the impact of that is really monumental. So we have a ton of work to do in the United States and in New Jersey still. But I think what we've shown in New Jersey is you can create successful models for pretrial release that do not rely on money as the primary indicator of whether someone is in or out. And I should just say one more thing before I close, which is kind of following on what we did. California has since adopted or is in the process of adopting some bail reform schemes. And on paper, they look very similar to what New Jersey has done. But there's this one critical distinction, which is their presumption of detention or of release is flipped on its head. So under this proposed bill in California, if you're charged with any crime that includes either violence or the threat of violence, so you get arrested for a minimal offense and you tell the police officer, I'm going to punch you, and you don't do it, you just say it, there's a presumption in California of detention. And I think there's this real risk that we will do what we call bail reform. We will try to change our pretrial system, but we won't do it with that eye to liberty, to ensuring that liberty is the norm and that detention prior to trial is the carefully limited exception. And when we do that, we really risk having the opposite effect, which is increasing the number of people incarcerated pre-trial. Thanks.
Thank you, Alex, for really describing how, in that jurisdiction at least, they're really trying to put into practice this idea that liberty has to be the norm and we can't be detaining people just because they're poor, which is what's happening in too many countries. So our next speaker is from India, Madhurima Dhanuka. She's from the Prison Reforms Program Coordinator, from the Commonwealth Human Rights Initiative, and she's going to talk to us about efforts to reduce pretrial detention in India, understanding the unique context there, that it's going to take you a long time to get to trial. So even if you are innocent and you are found innocent, you've effectively already been punished if you're in detention for years waiting for trial. So, Madhurima?
So good morning, everyone. So we've heard today a lot about measures and strategies for reducing pretrial detention, and we looked at examples from Finland, New Jersey, and Brazil. I'm going to talk to you about India, as Jennifer said. In India, we do have, so while there is definitely a need for legal aid providers to challenge pretrial decisions, there is also another role that I believe legal aid providers across the world should be playing, and that essentially links to ensuring that everyone is represented by being present in courts, by being present in prisons, and to be able to make immediate interventions even in cases which are defended by private lawyers. Because I think in the Indian context, even the private lawyers need a lot of monitoring, and the Bar Council isn't yet able to do so. And sometimes we do come across a lot of prisoners who are not effectively represented. Now, essentially, they have private lawyers, so legal aid lawyers would not have jurisdiction because they are already represented, but we have put in some mechanisms very fairly recently which do look into that as well, and I'll be talking about them later. So first, I'll talk to you about the rates. So we have around 1,401 prisons, and there's an average occupancy rate of 114.4%. Our pretrial population is around 400,000 prisoners, and a massive 67.2% of these are pretrial detainees. Our incarceration rates are not very high as compared to other countries, but the total prison population is ranked 5th in the world. In terms of period of retention, around 25.1% of our under trials spend more than a year in prison. I'll quickly move on to that. So this is the period of detention. I'm not sure if you can see how it goes, but the one above is the one which is up to 3 months. Then you have 3 to 6 months, then 6 to 12 months, 1 to 2 years, 2 to 3, and it goes up to 5. So it's very clear that while the majority of them are being there up to 3 months or till 6 months, at the same time there is quite a substantive number of them who are actually spending a lot of time. And as Jennifer correctly said, which means essentially a lot of people who may be innocent have already been punished for a crime that they never committed, or even weren't even there present when it happened. So now coming on to the framework, I think it's important to talk about the legal aid framework and how it works in India. So we essentially have, there's a National Legal Services Authority which is at the center, which is the main primary body set up under the Legal Services Authorities Act in 1987. Then we have state, district, and taluka legal services, which means every subdivision, every district, and every state has its own legal services authority, and this is the hierarchy that is formed. We also have legal services clinics, committees at the High Court and the Supreme Courts as well, and that's for appeal cases and also original jurisdiction of these courts. In terms of, we do have quality measures, but I'm not going to talk about them now because we have sessions later on to deal with that. In terms of legal aid providers, so when it comes to persons in custody, we have panel lawyers, but we also have a specific set of remand lawyers and jail visiting lawyers, and I'll talk to you about them later on. Then we also have paralegals. We invested a lot in our paralegal system quite some years ago. We have community paralegals, and we also have convict paralegals, and that too I'll talk to you about next. So in terms of measures, so where do you find the measures? So the legal aid measures I've put into 3 places. So we have measures at the court, we have measures in the prison, and we have another unique measure that we started in 2015, which talks about review of prisoners, review of under trial prisoners. All of these measures do have legal aid at the center of it. Either legal aid is the service body, or it's the regulating body, it's the nodal body. In some way, legal aid authorities are linked to all these. Now, if you look at courts, So in the code, what do we have? So in every code, every production code, we have remand lawyers. The remand lawyers are assigned to every court. They are supposed to be, a list of the remand lawyers is supposed to be present with the judge. The names of the lawyers are to be displayed on the walls so that people can contact them. So as soon as someone comes for production, if the person does not have a lawyer, the court is mandated to appoint a lawyer for him from the list. Now, in practice, things have improved. It wasn't really implemented very well a few years back, but then in the past 2 years there's been a lot of emphasis on monitoring and on service delivery, and now I can say that it's really we have ensured that a lot of people don't remain underrepresented at that time. Now, in addition to this, so this is about pre-trial as in remand stage, but even in terms of your trial, so even because of what happens a lot of times is at the initial stages, that is during arrest or when you are in your remand stage, you still have money to have a lawyer. But as soon as you go into trial and it's 1 year or 2 years behind, you're not working, your family might not be there, you run out of money. And then the lawyer refuses to work for you because he doesn't get his fees. So now what happens? How do you ensure you get a legal aid lawyer then? So for that also, the courts have powers under the code, under the criminal code, where they can assign a lawyer for you the moment they realize that you're underrepresented. So the courts also have an obligation to assign you a lawyer at that point of time. And then in terms of the right to legal aid, every person in custody in India is entitled to legal aid. There is no means test. There is no other test. If you are in custody, you are entitled to legal aid. So we do, that means, of course, essentially all the 400,000 prisoners are entitled to legal aid. So now if you move on to prisons. Now here again, not many countries across the world have so many mechanisms that essentially we have right now. So we have prison legal aid clinics. So every clinic in every prison in India, which is the 1,401 prisons, is supposed to have a prison legal aid clinic. These clinics, if you look at the numbers at present, they are around 1,145 clinics have already been set up in these prisons, and this is something. This mandate came in 2016. Then. These clinics are manned by the jail visiting lawyers, they're a subset from our panel lawyers. So we have jail visiting lawyers, and we also have convict paralegal volunteers. So we have trained convicts that are there, long-term prisoners, into convict paralegals who are trained to identify prisoners, who are trained to provide the basic legal advice to them, write down their names. If they need legal assistance, they maintain a diary. Then whenever the jail visiting lawyer comes to visit, they then introduce him to the lawyer, they explain the case. So we have convict paralegals. Now convict paralegals are not available in all the prisons. So where they are not, then we have community paralegals who are visiting to do this job for them. And the way the prison legal aid clinics work is essentially they are the communicating body between the prisons to the DLSAs or the legal service authorities, so that there is information flow between these agencies regarding the case, the status of the case, the lawyers, their functioning, not functioning, any grievances. So the prison legal aid clinics are that one-stop solution center. Now, there is another aspect is, so the prisons have also been empowered, the prison superintendents or the officers in charge are permitted to inform the DLSs, the legal services providers, about any cases that need immediate attention. Now these might not necessarily be legal aid cases. They can actually be private cases also, but it could be someone who has completed their term, but they're still in prison. So the prison officer in charge is entitled to inform about these to the legal aid authorities, and they can then take action thereof. Now, the third measure that I talked about was the periodic review of cases. So in 2015, India set up these under-trial review committees in every district in India. These were set up under the Supreme Court directive. The members are basically the chief judge, the district magistrate, the superintendent of police, the officer in charge of the prison, and then you have a member of the legal services authority. Now the legal services authority in NALSA was made the main nodal agency for the implementation and coordination of these monitoring committees, these under trial review committees. Now these committees, the mandate is clear. The mandate is to review all cases of under trials every quarter. So there are certain categories, I'll talk to you about them later, but the mandate is to check any form of unnecessary and prolonged pretrial detention. Now the categories, the 14 categories are there under which cases of prisoners are eligible. Now what the committee does is they review these cases, and where there is a need to recommend for a release or any action to be taken, they do that to the concerned court. And then the concerned court can then take action on this. Now, in these cases, a lot of times it is the legal aid lawyers who are then assigned to represent in these cases in the petitions or whatever action needs to be taken in that regard. Now, in terms of the categories, I'll talk about the main ones. So we have a law which prohibits incarceration of people beyond the maximum term of imprisonment. So to check for eligibility under that. For cases, there are a large number of cases where bail has been granted, like we heard from the US about bail was granted, but the person doesn't have money to pay surety. So in those situations, what do we do? So the lawyers are given charge to go and file for a waiver or for a reduction of fees. So those cases also come under review. Then we have where there's been the delay in the police investigation, there's a statutory period of 60-90 days for your release. If its investigation is not completed, then you are entitled to release. However, a lot of prisoners are not even aware of this, which means they spend, even though they are eligible for statutory bail, they are not released. Then there's eligible for prisoners who are eligible for probation, prisoners who are there for petty offenses, for compoundable offenses. Then we have prisoners who are infirm, women, mentally ill. They also have a special, their cases can also be reviewed to check if there's anything irregular in their incarceration or the procedure has not been followed. Then you have, there are certain cases where there has been inordinate delay. So even those cases are supposed to be reviewed and checked on why it has not moved or why, and in those cases, then bail can be filed for release. Persons who are detained under preventive detention laws or for keeping the peace, we have a huge problem in certain parts of the country where police just arrest people under notions and they just send them to prison. And these people are essentially people who have no idea of what has happened to them. And they often turn up, and if you ask them, they're like, I don't know why I'm here. And I also don't know till when I'm here for. And these are sections where incarceration is not even warranted, yet they end up there. So these categories were also included in the categories for review. Now, there's a legal aid measure at the police station. I didn't include them in what we're already doing because we are still in the middle of actually getting this done. So there is a right to a lawyer at arrest, there's a right to a lawyer at interrogation. There is, of course, all persons in custody are entitled to right to legal aid, but right now in terms of a system, we only have paralegals who are attached to police stations, who are supposed to visit a police station whenever they are informed of the arrest of any individual and ensure that the person has legal representation. However, the NALSA has put in process, they are working on a protocol for ensuring early access to legal aid lawyers. That means a legal aid lawyer will need to be present within 3 hours of an arrest of a person in the prison, in the police station. But this is still very new, so I haven't put it as a measure we already have. It's something that we are really looking forward to have because a large number of our arrests are considered unnecessary. And there have been a lot of reports by the parliamentary committees, by the Supreme Court, by researchers, which lead to this, that a lot of arrests are actually unnecessary. And maybe one of the solutions to our pretrial detention rates is the fact that if you have stricter scrutiny at the time of production, at the time of arrest, you probably will end up with a lesser pretrial population. So these were in terms of the measures that we have. And there's something about legal aid and about its role. So the undertrial review committees are, again, as I said, NALSA is the nodal authority. So all of these are being implemented by legal aid lawyers. And the role of legal aid lawyers in India is it was considered to be a very, people weren't really interested. I think there were no incentives earlier on to be as a legal aid lawyer or to be seen as part of that because it essentially meant that, oh, you don't have a good practice, that's why you've gone to legal aid. But there's been we can see that there is a certain change. There are more interested lawyers coming up as being legal aid lawyers. We have students and we have paralegals, motivated paralegals who are doing this. And very recently in a consultation that was held at the launch of our national report on legal aid for persons in custody, one of the senior judges actually claimed that legal aid lawyers are human rights lawyers. And I actually agree with that point that to some extent, when we talk about pretrial detention, we talk about torture, we talk about illegal illegal custodies, we talk about arbitrary arrest. To some extent, yes, legal aid lawyers do have a role, and we are human rights defenders to that extent. Thank you.
Thank you, Madarima, and also for segueing us well into our last speaker, talking about the scrutiny that needs to be there at the time of arrest. Holly Hobart is a program director with the International Legal Foundation, and she's going to be talking about the work that we've been doing in jurisdictions around the world to actually litigate illegal and arbitrary detention. And one of the things that we found is that if you do not have a process for actually allowing the legal aid provider to go into court and to address these issues, you're never going to change these illegal actions. So, Holly.
Hi, good morning. As Jennifer said, my name is Holly Hobart. I'm a program director at the ILF. And as my esteemed colleagues have already discussed, criminal defense lawyers must engage in, they must improve upon, and make early pretrial release requests on all cases. But in a conventional release request, the lawyer's not necessarily arguing that the detention is illegal. Rather, that the accused should be released on bail factors and based on discretion, although I do note that laws are changing, so actually there's starting to be some places where there's less discretion around pretrial detention. But I want to talk about what happens when your client is actually being detained illegally. It's a violation that happens early in the process, soon after arrest, and because of that, lawyers have to take action early, right? So this isn't a violation that can wait to be raised to the court in the final defense argument. Pretrial motions are a tool for lawyers to protect these kinds of rights, and they enable lawyers to actualize and enforce rights. So the ILF is introducing pretrial motion practice into our country programs. Pretrial motions are a form of litigation. So what is litigation? It's a contest, a controversy, or lawsuit brought in a court of law. One definition I particularly liked when looking it up was that litigation is what happens in court. And so the important thing here is that the argument and the application have to be made to the court, right? Not to the prosecutor, nor to the police, but to the court with a demand for action and decision. So demands to other parties, like the police or the prosecutor, may sometimes be necessary, but I note that that's something different, okay? It's not litigation. The English word motion comes from the verb to move, right? So when a party is submitting a motion, they're actually trying to get the court to move, or they're trying to push the court to decide on an issue of law. Critically, the motion must also demand a remedy in the event that the court agrees that there's been a violation, because without a remedy, the right itself has little meaning. So my presentation is an introduction to pretrial motions, specifically around this issue of illegal detention. But we've actually just released a primer on pretrial motions generally that covers the basics of introducing this practice into developing legal systems. And it provides a little bit more of a how-to or practical guidance on it. And I believe it's available outside the hall. And I'd invite you all to read the primer, comment, and provide your insight on how we can make it more helpful and more generally applicable. So the fundamental principle underlying pretrial litigation is that for every right, there must be a remedy. This principle is a basic human right, as reflected in the Universal Declaration on Human Rights, and it's also a bedrock of the rule of law. I think we're all probably fairly equipped to have a conversation on rights, but what about remedies? So what is a remedy? In medical terms, a remedy is something that makes a sick person well again, right? And generally speaking, a legal remedy is a response or a consequence to a violation of law. So a legal remedy may compensate the victim or attempt to return the victim to his or her original state. Legal remedies can also be used as a preventative measure to address systematic violations so that the violation doesn't happen again. So in other words, remedies can be used to fix problems in the system. In short, I think legal remedies ensure due process and support the rule of law. An important first step for pretrial motions is the recognition by the court that they not only can, right, they not only have the authority, but they actually have the responsibility that they must provide legal remedies for rights violations in order to fulfill their mandate to enforce the rights enshrined in their laws. So the right here, again, is the right to be free from arbitrary detention, which is also a fundamental right recognized in the Universal Declaration. And there are a lot of examples of how governments pass laws designed to protect this right. The Myanmar Constitution, for one, mandates that no one can be detained after arrest for more than 24 hours without being brought before a judge, at which point issues of arrest and detention and possibly other early issues should be raised with the court and decided upon as a check against police power, as a check against arbitrary arrest, and as a check against arbitrary detention. Further, there's going to be statutes that set legal standards for detention. So in terms of who can request the detention, who can decide upon the detention, under what circumstances can it be granted, for how long, etc. And there's several examples from all country codes. I'm using a Palestinian example here as I think it's clear, and I think it's similar to several other countries' relevant provisions. So as you'll see in the beginning section of the statute, it sets out a standard for detention and who the deputy prosecutor has to show that investigation couldn't be completed within 24 hours. And then a judge, a conciliation judge, actually has to make a determination to remand, and that remand order cannot extend past 15 days. I'd also like to mention Tunisia's June 1st law, Special Law Number 5 of 2016, that marks an important step forward for justice for all suspects in Tunisia. It introduces several important procedural rights for detainees, including protections around the right to counsel during investigation. But how does Tunisia actually implement this law, right? For one, lawyers are going to have to litigate violations under the law. There will also be much opportunity and necessity to litigate these issues under Nepal's new criminal procedure code, which sets up early access rights and procedures. Again, in Myanmar and the 24-hour rule that I introduced earlier, this means that defense lawyers have to be at that 24-hour hearing, representing their clients to ensure that the police and court are upholding the sections of the criminal procedure code, right? Section 167, which is very similar to 119 for Palestine. And finally, I'm sure my colleagues from Afghanistan, that this will sound familiar to many of you as we've been analyzing sections 99 and 100 of your criminal procedure code, which set out standards for detention and requirements for hearings. So, now to remedies, right? What is the appropriate legal remedy if someone's right against arbitrary detention is violated? What do you do if your client's being illegally detained? I hope it's obvious at this point, and unfortunately I'm no PowerPoint expert, so I couldn't hide the answer. But you know, the appropriate remedy for illegal detention is release. Release. And so habeas corpus, for those of you that don't know, is where used one of the most effective pretrial motions for challenging illegal detention in a timely fashion. It is a centuries old legal action stemming from England that can generally be brought at any time and requires that the person being detained be brought immediately before a court, right? So habeas corpus is actually Latin for to produce the body. And this right to challenge one's detention, it's well settled in international human rights law, including the Arab Charter on Human Rights and the ICCPR. can't quite see the top of that. Some countries have enshrined the right in their constitutions for habeas corpus. Others have a combination of constitutional and statutory mechanisms to challenge the detention. And while there may be no explicit reference to habeas corpus in a particular country's code, there should be a provision which can be interpreted to allow for an application like a writ of habeas corpus, or at least to provide for hearings or court dates where defense counsel can raise the issue. And this is from the Criminal Procedure Code of Afghanistan, where there is no explicit reference to habeas corpus, but it's a clear requirement for a detention hearing, an illegal detention hearing at any time that applies to suspects, accused, and defendants, which we argue means that it starts from the time of arrest. Regarding habeas corpus, I also want to mention, I'm sorry, Nepal, something happened with the colors there with your flag. But I'd like to mention the work of our lawyers in Nepal. On that side, it's right. Who have been successful in bringing habeas corpus challenges and getting countless people released who have been illegally detained on low-level offenses. So the habeas corpus provision is enshrined in the Nepali constitution, and our lawyers brought challenges around the some public offense, which is a petty law statute, which says that a case has to be brought within 7 days. And so that statute, taken and argued in conjunction with remand statutes, led to successful habeas corpus claims, which we then brought on several people being detained on SPO cases. And this work in Nepal, I think, is also illustrative of another important point on pretrial motions, and it's my last point, which is that time restrictions are an easy way to make a claim for an illegal detention, but they are by no means the only way. There are, several violations of rights and law that could make the detention illegal. And going back to Nepal again and the SPO cases, they actually used a habeas corpus mechanism to argue a jurisdictional issue, which was that effectively the quasi-judicial bodies adjudicating SPO cases didn't have jurisdiction. So they took a jurisdictional argument to say that the client was being illegally detained. And that was an argument that we won in the Supreme Court. Another big issue, I think, that's relevant here is that an illegal detention claim can stem from a violation of the right to counsel. So, to put the argument simply, if the right to counsel commences at the time of arrest, then that means that everybody has a right to counsel in detention, right? And so, if a detainee does not have a lawyer during interrogation or investigation, then the detention is illegal and the person should be released. I think there's also, we heard a little bit about issues around reasonableness of bail, and I didn't add it on my PowerPoint, but this idea that bail can be applied in a discriminatory fashion, such that if somebody is in on bail that they can't afford simply because they're poor, that could also be argued to be an illegal detention. So all of these types of issues call for effective pretrial litigation. And I would just note in closing that they may also call for other remedies, right? Alternative remedies other than release. So maybe suppression or exclusion of evidence that's obtained illegally, or a pretrial motion to dismiss based on a violation of law or rights, or a lack of evidence. And these illegal detention hearings and motions, as well as just general release motions and jail bail hearings, et cetera, they're a springboard, right? So they're an opportunity for lawyers to be raising these pretrial issues early and on all cases. And I'll just close there, but again, I would point you all to our primer. It does have some more information on other grounds for pretrial motions, further support for developing a practice, and I'd welcome a discussion further. So thanks.
Thank you, Holly. And I should say about that primer as well, one thing that we'll be adding are sample motions that can be adapted to different jurisdictions, because I think that can be a really helpful tool as well. So we have about 20 minutes for questions, and maybe we'll do a couple of rounds if we can get 3 questions and then some responses from the panel, and hopefully we can do that a couple of times at least. Yeah.
Good morning. My name is Krasimir Kanev, and I come from the Bulgarian Helsinki Committee. I have a question to Nina. It relates to the statistics that she provided for convictions of children. This is quite high in terms of numbers. It compares to our numbers, and we always thought that we are tougher on crime than the Finns. But my question is different. Is there any other system of formal social control of children? In many countries of Eastern Europe, when a child commits a crime, he or she does not necessarily go through the criminal justice system. There are other systems imposing, for example, correctional measures or educational measures, detention for the purposes of educational supervision. We have this in many countries of Europe. Is there such a system in Finland, or you have got criminal justice for any type of offense and nothing else?
Good morning. Many thanks for the presentations. I have a question. I'm not sure if it's relevant, but maybe we can have some examples. In Lebanon, the physical arrest, so the pre-charge arrest, it's really a gray area. I'm not sure if we can qualify it as illegal detention, because somehow the national legislation is not really clear about this period. And usually even if we're talking about a couple of days, this is where we can have severe violations. So maybe we can talk about some remedies, not necessarily legal reforms or strategic litigation. Thank you.
Bonjour, je suis Anwar Menasri de la Tunisie. Et j'ai quelques questions. Tout d'abord, il faut, pour la conception de la détention provisoire, elle dépend, à mon avis, de différents piliers. Le premier, c'est la Constitution et la loi. C'est un socle très important pour garantir les droits des détenus. Et en Tunisie, ça a été prévu dans l'article 28, et non pas 49 de la Constitution, c'est que le détenu doit être accompagné par son avocat. Et l'article 49, ça parle de la liberté et qu'on ne peut pas restreindre la liberté que pour... What?
We're having a problem with translation.
Ah, okay.
Okay. So just... the interpreters are just requesting just to go a little bit slower if we're going between languages with questions, just so that they can prepare to do the translation. So just for the interpreters, are we ready to start again? You're not hearing.
Okay. I will try to speak in English, but it's not a good English.
Or maybe Arabic?
At Arabic, there's no فمش traduction in Arabic. I don't know. In
Yeah,
Arabic,
there's Arabic translation.
Arabic I can.
Is it better if we do Arabic? Okay, maybe try.
I can in Arabic. الإيقاف التحفظي مرتبط برؤية شاملة ودامجة لهذا الإيقاف. هناك أولا الإطار القانوني الضامن لإيقاف تحفظي وفق المعايير الدولية. It's okay?
Yeah, okay. Sorry.
Yeah. أنت تعمل traduction? Je fais en français? D'accord. Donc la détention provisoire dépend, c'est une vision globale et inclusive.
Tu hostes ta voix.
Ah, oui, vous n'avez pas entendu?
Tu hostes ta voix.
La détention provisoire dépend de différents piliers. Le premier, c'est d'avoir une vision globale et inclusive.
The pretrial detention is a general overview. That's what you said.
Vision, it's a global vision. It depends on laws, constitution, and it's the case in Tunisia. We have principle in constitution, it's article 28 and not 49. And also not only laws, but also we have resources, not only in material resource, but the number of judges. Because if we have si on n'a pas assez de ressources humaines au niveau de la législation, au niveau des magistrats qui sont tenus des magistrats en premier lieu, les lieux de détention en deuxième lieu.
If you don't have enough human resources in the judges and in the places where detention takes place,
les détentions peuvent être contraires même à la Constitution et la loi, question de moyens et non pas de...
And the detention will be in conflict with the Constitution and the law, not because they want this, but because of the weak human resources.
Il y a aussi la question si on parle d'un procès équitable de détenus dès la détention, il y a aussi la responsabilité de l'État. Il y a la responsabilité administrative qu'on oublie toujours et où l'avocat doit aussi prendre en considération lors de la détention.
There is the responsibility and the liability of the state during administrative arrest, and that we are always neglecting, and we have to take into consideration during such cases.
Donc je mets l'accent sur le contentieux administratif.
So I'm emphasizing on the administrative matters related to that.
Aussi dans la détention qui n'est pas seulement une approche criminelle selon les codes de procédure pénale.
Which is not only a criminal approach in such cases.
Thank you.
Okay.
Thank you.
Thank you. Thank you. Okay, maybe one more question, and then we'll, yeah? Since you were so kind to translate.
Okay. As we were listening with great interest of today's panel, it's about strategies for reducing excessive pretrial detention. And while all the group is preparing the Tbilisi Declaration on the implementation of the United Nations principles, I believe there is a matter that we are not really emphasizing on, but is very important, and we in Lebanon, we did experience this. It's the matter of how international donors are balancing their budgets for assistance, meaning, and very simple. For example, in Lebanon, for the last 20 years, if we count the budgets that international donors, the US, the European, the British, all these, are giving assistance to our security and army apparel, and I insist, we are very thankful for this and we want this to continue. But when we look on the proportion that was invested in the judicial system, meaning the courts, the legal aid, the tools for the courts, and all matters of rule of law matters, and prison assistance, meaning all the apparel that will help in the better treatment of the prisoners. The balance is way different. So I don't know whether it's possible to include in the Tbilisi Declaration that in order to have a sustainable development in such things,
there should be a certain proportion of the investment that all donors are giving to the security apparel. There should be a percentage, yearly percentage, invested in the development of the judicial system, meaning the courts giving better tools. I give a small example, you'll understand it very well. We have 1,600,000 refugees of Syrian in Lebanon. When we have more people incarcerated, the report of human rights of the State Department of the United States will come and say, okay, we count, there used to be 5,000 inmates, now we have 9,000 inmates, your report is negative. But why we have more people? Because we have more refugees, but we have a stronger security apparel. But we still have the same number of judges, the same prisons, and the same tools, and the same cars to transport prisoners from the prison to the court. So many times there is delays. We don't have enough space to transport the prisoners from their prison to the courts, and it is delayed. So this is a very important thing to emphasize, invest a certain percentage of whatever we invest in the security apparatus and the army in the judicial system. This is the best way to have a good response to such strategy to reducing excessive pretrial detention. Thank you.
Thank you, thank you. Point taken for the Tbilisi Declaration. So let's start with Nina. Do you want to respond to the question that was put to you?
Yes. I'm sorry, I was probably a little bit unclear in my statistics. First of all, I have to emphasize that these convictions mean also that they get fined. So these are not prison convictions, but most of the children get fines. And yes, we do have different kinds of means to deal with children. First of all, there is a youth police. There is a police that is, once the child goes to the child between 15 to 17 goes to the police hearing, he or she will be named a certain police. So the police gives him or her this speech that okay, we will see the first time, but next time I see you, I don't want to hear the same explanation. So that is something that hinders the children to if they once do a stupid thing, they remember that next time they can't say that, oh, I'm sorry, I didn't think about this. The police knows them and knows what they've done. And these policemen and women, they are really good with the children, and they usually take a very lenient position with the children. For instance, once I was there with twin boys who had shoplifted from a shop, and I asked the police that is it possible, because they are really good kids and everything's going fine with them, that could it be possible that we could go to the shop? It was a big department store, and I asked them that could we go to the shop and speak with the people there, that is there some kind of way to compensate what they've done, and this was all right, and we went there and we had a serious discussion with the shop owners that this cannot happen again, and what can they do to compensate what they've done, and it was all right. And then we have also the ways of mediation. So when, for instance, two children have fought with each other to 15 to 17 years old, and there's not major injuries, some more lesser injuries, then we can go to mediation, and there can come lawyers also, but usually it's the children and their parents and the mediators that then discuss that what can be done so that this doesn't happen anymore, and of course then how to compensate if the other party has injured somehow. So those kinds of means we do have.
So the other two questions I think weren't to any particular individual, but as Holly, thank you.
So this is just a clarification on the reference to the Tunisian constitution. I was referring to Article 49, not to point out pretrial detention regulations in the Tunisian constitution, but to show a constitutional mandate that the judiciary actually has the responsibility, has a legal obligation to enforce the rights that are provided for in the law. And the way that they can do that is by providing legal remedies, right? So lawyers have an obligation to make arguments that if their clients' rights are being violated, and to demand a remedy, and then the courts actually have a legal obligation to provide those remedies. And I would kind of dovetail that onto comments about administrative or budgetary financial shortcomings. That's not the problem of the detainee, right? So actually that's even more of a situation where the court should be releasing these detainees because they're being illegally detained, maybe just as a matter of circumstance and not through any intentional fault of anyone involved. But the way to, I think the fastest way to solve that problem is through release. And also dealing with police misconduct, right? And this is what I mean by a prophylactic, or I used a preventative measure, where if these remedies are provided based on police misconduct, for example, police are going to stop abusing detainees so much if the people they're abusing are being released and their cases are being dismissed. And then I just had one more comment about the arrest argument. Without doing sort of more legal research around it, I do think it's a very good issue for strategic litigation. At least in the United States, right, there's a whole lot of case law and precedent around the fact that detention starts from the time of arrest, or any time that the person is no longer free to leave. And so, it's a matter of interpretation of the law, and lawyers making creative arguments around that, and then pushing that argument all the way through the courts.
So I also want to respond to our friends from Lebanon, the two different questions. And so first on the point Holly was just talking about, there's got to be some standard for taking someone from their everyday life and bringing them to either the police station or to the jail. And so in the United States, that's probable cause, and there's a right to go before a judge. So everything I talked about kind of presupposes that first police were able to show that they had probable cause to detain the person. And that doesn't have to be the standard, but there has to be a standard for arrest, and I agree that otherwise it's really ripe for litigation. On the question of resources, I was struck by it because it actually reminded me of the conversation yesterday about plea bargaining and something that Rick was saying, which is, it's true, right now our system needs plea bargaining to survive, but that's because our in the United States at least, our system is so beefed up on steroids. It's so wrong-sized. So if you got rid of plea bargaining, you would have to right-size the system. And it's the same thing. If they want to increase the security apparatus, increase the number of people who are arrested, then they also have to kind of have a kind of corresponding increase in funding for legal aid, funding for judges, and so forth. And so I've seen models in the police accountability world where accountability mechanisms are tied to a percentage of the police budget. So if the police want to raise their budget a ton, that's great, but then the accountability mechanisms have a corresponding increase in their budget.
I'm going to give the last word to Anika, and then I think we have to go, unfortunately, to tea break, but we will continue these conversations in the next
Yes, thank you. Just really quickly, and thank you very much for the statement from Lebanon. Of course, we wholeheartedly agree. I think UNDP will second that. And just when you think about how to include it in the declaration, just some food for thought, what we have been doing lately when we argue with countries that want to donate funds to increase law enforcement, the work against organized crime, and then we have to argue their contributions for access to justice and prison matters, is also to highlight the link to all of these measures reducing recidivism, because we have studies, we all have numbers, I think, from all over the world that really show that if people are treated well, in the system, if people are released early, that it really has an impact, and also the aftercare, the resocialization, which all is linked to how they were treated in the prison system. So we use it towards states as an argument to say, this is in the end also a spending that comes back to the safety and security sector, because these people, if they don't recommit crimes, then the police doesn't have to deal with them again, and they are not violent, so they are less victims. So I would suggest to somehow link it, because the more you stress it, the more it sinks in.
So now we have a tea break. If I can just ask everyone to come back in 20 minutes instead of 30 minutes, we'll try to catch up with the program. Thank you.